Happy Tuesday, everybody. It's coffee and Cursey words. It's 420. It's all the things. So a brief bit of housekeeping. Today is going to be a shorter coffee and Cursey words because Apple is having an event. And I know a lot of you want to watch. I want to watch. If you follow me on social, I'll be sharing what I think there because you know I'm a giant tech nerd. Though we do legal commentary here, I love tech. So I'm very curious to see what comes out. If you are in the replay crew, timestamps will be down below for the things that we're getting into. I am going to talk today a bit about criminal trial practice in the US. I know people have been watching the Chauvin trial. I've gotten a lot of questions about things. So I'm going to talk about kind of the trial process and particularly closing arguments and what comes next from my perspective, because that's the job I used to do and did a lot of trials. So I'm going to share that perspective. As always, when we are talking about current events, hot button issues, things that are divisive and or challenging, we always stay respectful in the chat with no name calling. There are a lot of feelings about this case, but we are going to just talk about the closing arguments and how that plays out in the law, not what should or shouldn't have been done, what should or shouldn't happen. The jury is deciding. We will see what they decide. I appreciate the law nerds who always keep it respectful. I say it more because every now and then people join who aren't familiar with how we roll here. And I always want to say, hey, this is how we do it. For all of you in Minnesota, I am sure that this is tremendously stressful, kind of waiting for this verdict to come down. And for everyone who's waiting for this verdict to come down, it feels very heavy. But let's talk through the process of law from the experience of someone who's given a lot of closing arguments and then court of public opinion real quick, and then lots of time for questions. So that's the goal for today. We should just get into it. So let's just get into it. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the Cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. So as always, when we talk about topics, I am going to talk about kind of the breakdown of what trials look like and then questions. If we don't get to court of public opinion, because I realize we are short on time today, we'll cover it Friday. The polls are still going on. We have both sides of the bracket covered. I will be updating the bracket on Twitter and on the community tab with all the winners filled in. It's interesting to me that the votes on Twitter and the votes on the channel sometimes are a bit different, but generally have the same sentiment, which is so interesting to me. All right. Closing arguments. And then questions. So let's talk about what that is. Let's just jump into it. So from the perspective of me, I was a deputy district attorney for over 10 years. So I did criminal trial work. And though I have worked in aspects of civil, I did not do civil trial work. And because the questions I've been getting are about criminal trials and criminal procedures, I'm going to just touch on how the criminal trial works, what closing arguments are, since that's particularly relevant given the fact that the Chauvin trial just closed, and then what a jury does next. If you've been on jury duty, you might have seen this from the perspective of being a juror. If you're watching internationally, trials happen differently all over the world. So this is a breakdown of how trials generally happen in the US. Sometimes the names are different depending on the jurisdiction that you're in. They call certain things different things. I practiced in California, so that is what it is. For the general criminal trial, you start with law in motion starts before you ever pick a jury. So you go through the process with a criminal case to get up to the point where you're going to go to trial. And then there are motions and arguments regarding what evidence is coming in, what witnesses are going to be heard, any issues there may be. And you can even start talking about jury instructions at the beginning if there's things that need to be written, if there's things that have changed in the law, because the jury instructions are the law that is given to the jury, and that is their roadmap for how they're to determine their verdict. So that happens before jury even comes in. Then you get to the day where it is time for jury selection. A veneer is pulled into a courtroom. Now, again, this is all pre-COVID because COVID has changed the way this happens in a substantial way. It used to be that you had all of the seats in the courtroom filled, and then you would fill in what's called the box, the jury box, with, your 12 jurors and however many alternates you might seat. So you might end up having 14, 16, 18 people up, and they are numbered. In California, all jurors go by number. Their ID badges are by number. And so you do it all by number. The attorneys are sitting in the courtroom, the defendant's in the courtroom, judge, court reporter. The state, the prosecution will often have an investigating officer that worked on the case that is with them at counsel table, but not always. And so you will start asking questions. That is your voir dire, your jury selection process. The judge reads them initial rules. The judge asks questions. The attorneys ask questions. And you go through that process. I had colleagues call it picky, guessy, choosy, which was like sometimes you can only determine so much about what a person holds kind of bias towards, if a person can be fair, what their life experiences have been that might predispose them to one side or the other. And that all happens during voir dire. And you try to pick a jury that is going to listen to the evidence as fairly as they can and render a verdict without bias. That is the goal of picking a jury. And you'll hear in closing arguments talk about that, but you'll hear particularly in jury instructions at the end, the judge talking about setting aside bias and things like that. So that is kind of how you get a jury. You pick a jury. There's a lot more that goes into voir dire and peremptory challenges and exclusions and things like that. There are rules about how you can and cannot kick jurors. That's a topic, if you're interested, for another day. Then you get into the evidence. The prosecution, the government, the people present evidence first. Why? Because the defense doesn't have to present evidence at all. Underlying the American criminal justice system is the presumption of innocence. The defendant sitting there staring at a jury before a moment of evidence is spoken is not guilty. They are innocent until proven otherwise. And so they sit there innocent. The state has to build a case against them and prove it to the jury. That is their job. They also have to adhere to the rules of evidence, the rules of the Constitution, prosecutorial ethics, and other things. So the prosecution presents their case. This is normally much longer than a defense case, and that is because they have to prove each element of a crime beyond a reasonable doubt to the ladies and gentlemen and persons sitting in that jury box. After they present all of their evidence, the people rest. They rest their case. They are done. No more witnesses. At that time, the defense can bring a motion. At that time, the defense can choose to present a case. Sometimes at that time, I forgot opening statements. I forgot to even mention it. We jumped right into the people's case. After the jury is seated, there are opening statements. They're not called opening arguments. They're not supposed to be arguments. They're supposed to give the jury a roadmap of what they're going to see. I'll talk about the theory behind that in a minute. The people present that. The defense can present an opening statement at that time, or they can reserve it until their case. So the people make an opening statement and can go right into evidence, or the defense makes an opening statement and then the people go into their evidence. After the people rest, there are motions that can be made. There are things that can be dealt with procedurally, and then the defense can make an opening statement if they reserved it, or the defense can keep presenting evidence, or the defense can rest and not present a single shred of evidence. They are not obligated to. They don't have to. They do not have to present anything, but they can. Often the defense will present witnesses and what have you. The defendant will be given the opportunity to testify on their own behalf. They do not have to. They cannot be forced to. Constitutional rights and all of that. They cannot be forced to testify against themselves. Once the defense is done, the defense will rest, and then it is time for closing arguments, which is what we're talking about a bit today. Before you get to closing arguments, of course, there will be more discussion with the judge where the jury will be excluded from it. So the jury goes back to their jury box or home for the day, depending on the time. And then the defense, the prosecutor, and the judge go over the final versions of jury instructions, deals with any of the necessary motions, deals with anything that could have happened in the trial. The defense can make different kinds of procedural motions depending on what happened during the case, can move to dismiss the case, move for a mistrial. These types of things can happen at the close of evidence. And then they will finalize those jury instructions. The jury instructions are critical. That is what the jury will hear from the judge that instructs them on the law that they are to apply. So the lawyers bring the evidence. The lawyers tell the jury, this is the evidence. The jurors decide the facts and apply it to the law. The jury instructions provide the law. They are dense. They are often long. They can be a little convoluted. I always preferred when a judge would instruct the jury on the jury instructions before closing arguments, because then I could go through, well, I went through it anyway, but then you go through the different jury instructions and talk to the jury and tell the jury how those instructions match with what you proved or didn't prove in your case, depending on if you're the people or the defense. And once the judge pre-instructs, if they pre-instruct, you have sometimes an hour, sometimes more than an hour, where you are listening to the judge, making sure the judge accurately reads the jury instructions, because that can be an issue. It happens. And then you get into closing arguments. Often those are long. Not always. It depends on how long the evidence in the case took. But you can see closing arguments take days. Thankfully, in the Chauvin case, we did not see that. I've never argued on closing for days because I don't think a jury can pay attention that long. I don't think anyone can pay attention that long. I don't think anybody wants to pay attention that long, but it can happen. Different jurisdictions have restrictions on how long closings can go. Different judges have restrictions, but they're generally limited because that's when you argue the case. That is really the only argument in court. I mean, yes, you see lawyers asking pointed questions on cross-examination, but arguing the case is your closing arguments. And those come in a set of 3 in criminal trials. The prosecution closes, the defense closes, and the prosecution has the opportunity for a rebuttal or a second closing, depending on what the jurisdiction you're in calls it. That's because the people, the government, bears the burden of proof beyond a reasonable doubt. So they get that 2 bites at the apple to close. The defense attorney will only get 1. And the defense will often say, this is my only opportunity to talk to you. And I'm going to take time. Please bear with me. This is my only opportunity to talk to you. The people will get up here again. The people will often say, look, this is my kind of open close. This is my first closing argument, and you will hear from me again in my rebuttal. And that's because I bear the burden of proof to explain to the jury why you hear from the people twice and only hear from the defense once, to kind of not have their mind racing with questions of like, well, why am I hearing from you again? And what is happening? So that is the kind of process of closing arguments. And I'll talk about the theory of how you do that in a minute. Then you get to jury deliberation. The jurors, at the end of closing arguments, the jurors are excused to begin deliberations. Generally, they will start with picking a 4-person. That's normally the first thing most juries do. Then a lot of times they'll take an initial vote to kind of see where they are. The fastest I ever had a jury come back was like 12 or 13 minutes. I mean, we were still sitting in the courtroom wrapping things up to send them back the exhibits, because there's a lot of law stuff that happens once the jury walks out to start deliberating, the lawyers still have work to do and are there with the judge still working. And then the jury buzzed and we're like, do they have a question? And it's like, no, they have a verdict. I'm like, they didn't even talk about anything. They picked a 4-person, they took a vote, they were all on the same page, and they're like, okay, I guess we're done. Look, when they're all on the same page, that can happen very quickly. It tends to happen faster in cases that are less serious. In a case that is more serious, a lot of jurors don't feel right about just taking a quick vote and moving on with it, because it feels like the amount of time they've spent, and particularly in a murder case where there is a loss of life, it feels like it warrants more attention and discussion. Like the gravity of the thing warrants more from them. So some jurors will take an initial vote, some juries won't. Some will do it, roll call, some will do it by paper. They get to decide that procedure along with their 4-person. Jurors can then ask for exhibits. All the exhibits will be sent back to them. Everything marked as evidence will be sent back to them. Nothing that's demonstrative. So if a lawyer used a chart or a graph or made notes, none of that will go back to them. That's not marked as evidence. Only the evidence goes back to them. And they can ask for things if they need it. They can ask questions to the court. Often we'll learn a lot about what a jury's up to based on the questions they ask. I had a jury ask, I think it was on day 2 or day 3 of deliberations, ask that they sent a question out saying, after the verdict, can we have a police escort out the back? And how can we be sure of our safety? Something like that. And from that question, you kind of had an idea, based on everything that had happened in that case, you had an idea of which way the jurors were leaning. And that was very clear indication that they were leaning towards guilt for me and for co-counsel. And that's ultimately what they did. But sometimes those questions can very much indicate what they're thinking. Or if they ask for read back of a particular witness, that means they all come back into the courtroom. The court reporter pulls up the testimony and reads it back into the record in open court. So that is kind of what can happen with a jury. But normally once they're dismissed, they will go into picking a 4-person, taking a vote, and then either discussing, going through evidence, and really deciding how they're going to work through, as 12 people that don't know each other and haven't gotten to talk about this case, how they're going to work through all of the evidence they've been presented and trying to come up with a verdict. They're going to have to go through the jury instructions on each count and come up with a verdict on each count if there are multiple counts in a case. So for me, my kind of theory of closing argument was really to help the jury understand what the elements of each crime was, the crime, talk about what the elements of the crime were, and then how they know that each element was met beyond a reasonable doubt. And I would do that by reminding them of each bit of evidence that went to those individual prongs. So if there was, A, B, C, it would be like, as to A, you saw this witness say this, you saw this video show this, you saw this and this and this. That's how you know this is met. As to B, this is what it means. These are the things you saw. This is how you know that it's met. So for me, when I did trial work, it was always, I open at the close. I always had my closing arguments in mind, because you go into a trial knowing exactly what you have to prove, having a rough idea of what evidence you think is going to be presented. But as a prosecutor, you don't do depositions like you do in a civil trial. You will do some interviews, but witnesses will say what they say on the stand, and you don't always know exactly what they're going to say. Often you don't know exactly what they're going to say at all. Sometimes you have not had an opportunity to interview them, not in a high profile case, but in others. So my open was always very much, this is what happened on this day and time. This is the evidence we expect to show. And we, at the end of this, will be asking for a guilty verdict on these counts, because we expect the evidence to prove beyond a reasonable doubt that so-and-so did such and such. And keep it brief, giving them an outline of like the highlights. Oh, you need to look for this, listen for this. These are the key bits of testimony you're going to see, because asking people to pay attention day after day after day of people sitting on a stand talking through can be hard. So I tried to give them highlights of the key things they needed to look for. And the defense would often remind that it was, innocent until proven guilty, and then talk about any evidence they might show. Often the defense attorneys I worked with would hope that the prosecutors would over deliver in their opening. And then in the defense closing, they would come by and say, the people said they were going to show you this. Where is it? The people said they were going to show you that. Where is it? I have doubt. Where is the doubt? Could this be doubt? It seems like doubt. It is a reasonable doubt, not an unreasonable doubt, but a reasonable doubt. And so that's where opening comes into play when you get to closing. It also comes into play with how you take notes throughout trial, because again, the attorneys don't have recordings of what the witnesses said. So if you're working by yourself, often prosecutors, you have to ask questions of the witness, make notes of the things that they said that you are going to then use in your closing. So your brain, when you're in trial, your brain is always just in that thing, because you have to craft that all together in a closing that, for me, should be engaging, concise, and educational for the jury. Teach them how to take the steps to get to the verdict that you're asking them for. Teach them how to go through the jury instructions. Teach them what evidence they can find that goes to those elements. And then the defense is going to say, yeah, but this element's not met and there's doubt here. And the purpose of the defense closing really is to poke holes in what the people said, which is why they get a rebuttal, but to point at, this is where evidence wasn't met. This is where there's doubt here. This is the witness. Remember on cross, they said this, that kind of goes against what the people are saying that they said. And that's where you argue the different perspectives. Because again, the prosecution's perspective is this is guilty. The defense perspective is going to be there is doubt here. And arguing the things that the jury heard and saw and the different perspectives on it, advocating for their side, and then telling the jurors, ultimately, you are the finder of fact. The facts are in your hands. We've presented evidence. You determine the facts. And then if those facts meet these elements, crimes have been committed. And if they don't, then they haven't. So it's not really guilt and innocent. It's the jury's determining guilt beyond a reasonable doubt, or no, you didn't prove guilt beyond a reasonable doubt. Though we say that it's an acquittal or it's finding someone innocent, it's finding that the people haven't proved their case all the way, really. And that's why closing arguments are the most important, because they need to condense sometimes weeks of testimony, remind jurors of the things that they heard early on, which is why you try to put the maybe the scientific stuff that's not going to be hotly contested, the jurisdictional stuff, that stuff early on, because it's like, oh, remember the coroner said the thing? Great. Okay, moving on. And then the most impactful, or sometimes the most controversial evidence, that in controversy, in argument, not controversy in the sense of the world, but the stuff that the defense is going to argue with towards the end so that you have room to argue it. Though sometimes you could put that in the beginning and try to bury it and hope that the jury's forgotten about it by the time you get a week later, but the defense will not let them. And that is generally the purpose of a closing argument. You want to engage a jury. I can't imagine how difficult that would be during COVID, because you can't get close to the jury. You can't stand face to face with them. I would do closing arguments from, like, if the jury box was there, from in front of the jury box so I could look at the jury. And I would bring my exhibits into the area between the judge and the counsel tables, and turn it towards the jury so it was me and the jurors speaking. And I could see where they were looking. I could see if they were looking at me or if they were looking at defense counsel or the defendant. And if I had my investigating officer, he would watch the defendant and the defense attorney to see if they were making faces, indicating things to the jury, stuff like that. And watching the audience, because sometimes the audience can kick up, if it were. And there's also sometimes objections during closing arguments. There's things you are not allowed to argue in closing. There are things you cannot bring up in closing. And if there have been rulings during the course of the case where evidence didn't come in or what have you, you can't allude to that or touch on it And sometimes you can't argue the fact that it didn't exist. If the judge says you can't bring in this evidence, you can't get up there and be like, well, y'all didn't see this. No, you can't. You can't misstate the law. You can't generally comment on, saying, oh, well, that attorney's just lying to you or misstating the truth. You can comment on the evidence. You can say, this indicates that. But the arguments also have to fall within the bounds of the law, and the criminal law is very specific. So when it comes to closing arguments, my preference is concise, instructional, engaging. Now, the level of engaging is going to depend on the makeup of the jury and the nature of the case. More serious cases, more serious closings. It doesn't always sit well with me when lawyers try to have a gotcha moment in closing. And as I get into questions, we'll talk about that. But closings aren't really for that gotcha moment or that one-liner. They're really to, of course, unless it happens organically, they're really to tie together the evidence in a way that the jury can take your words back into the jury room and say, yes, but we know that this was proven because this, and this. You want to empower them to your side, really, so that they can say, no, this element was proven because of this, and this element was proven because of that. Because if there's a juror or two that isn't convinced, you want the jurors to be equipped to have that conversation, and you want your closing argument to help equip them to have that conversation, whether you're the prosecution or the defense. If you're the defense, you need one person to not agree, and that is a hung jury. And a hung jury means that they cannot come to a unanimous agreement. For a criminal conviction, all 12 have to agree. For an acquittal, all 12 have to agree. For a hang, one doesn't agree with everybody else. And that's not the case in civil. Civil does not have a unanimous jury when they come to a jury verdict. So the defense's goal is really to equip that one person or more to say, well, there's doubt for me because of this. That's what it takes for the defense to prove doubt and to kind of instill doubt. That is their job. So hopefully that is instructive about what closing arguments are, what purpose they serve in the criminal trial system here in the United States, and how those are used as you're playing kind of or giving yourself some background against what you've watched, what you've seen happen. And as we continue to see, I think, criminal trials in the US be more open to the public by way of being televised the way we saw with the Chauvin case. It was completely open and very, very transparent in the way it was aired to the public. And I think that A, leads to a lot of questions, but B, gives a very good opportunity for everyone to see how the justice system works in a trial, how the judge makes rulings, how the parties argue, how they present evidence. And I think understanding how a thing works can also illustrate how maybe it doesn't work too. And I think that transparency is always a good thing, particularly in our public trial system. So hopefully that was helpful. Let's get into questions. I know we're moving fast. I know we're moving fast. But I want to be able to get to questions. I want to be able to talk to y'all. And yeah, I want to be able to talk to y'all, really. And I've got mascara she's stuck. I don't know what's happening. So that's hopefully helpful. I'm going to get to questions. All right. And then I'm going to scroll back up. Tara, yes, in civil trials, you don't have to have a totality. You don't have to have all of the people. You just have to have some of the people. Dr. Badass has walked in. Do you need car keys?
I do.
Come say hi. You've got to come say hi if you're walking in. You weren't stealth at all. I totally. I heard you. Say hi to the law nerds.
Hello, law nerds.
Sorry, I've been meaning to leave them in the car so that you have them. I apologize.
That plan.
I appreciate you.
You did it yesterday, but it went south today.
I know I had my coffee and I was in my own brain already.
Got
All
it.
right. Enjoy.
Okay. All
And
right.
did you grab the Target card out of my wallet?
You already gave it to me.
Okay, good.
Yeah.
Bye,
I got it
honey.
last night. Bye-bye. Bye, Leonards.
Thanks. So,
You want the
Any-
cats out?
oh yeah, I don't want it, whatever. It's fine. All right. So yes, in civil, it's a preponderance. I see SC's already said it. In civil, it's a preponderance. So you can have, and it depends on the size of the jury, you can have a few that don't agree, but in criminal, it has to be unanimous. Sorry, as I get distracted. Will they re-prosecute if hung? Frida, that is a fantastic question. Thank you for asking it. After a hung jury, and I've had a number of juries hang. I had one. Ugh. It was a misdemeanor trial, and it still bothers me. And that was probably 15 years ago, and I'm still like, ah! Anyway, will they re-prosecute if it's hung? Generally, it will re-prosecute if it doesn't settle. Sometimes they will decide to resolve a case for a plea for a particular amount of prison time if they see that there's issues that could be appellate issues. Because if you plea, then there is no real appellate process generally because you've agreed to the thing that you're being sentenced to. So there can be benefits to resolving a case after a hang. If the prosecution doesn't want to offer a deal, if the defendant doesn't want to take a deal, then yes, they re-prosecute. And they can also take a look at what the appellate issues might be. In the Chauvin case, there are a number of them. Take a look at what the appellate issues might be in the first trial and try to fix that so it doesn't happen again if there is a second trial. And that might be things like moving a juror, blah, 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 blah. So, or moving the jury out of Minneapolis, things like that, giving it a little bit more time to retry so that the I don't know, the external weight of the thing is different. So it might not prejudice a future jury, things like that. So thank you, Christina. I felt like it was fast, but I also think being able to watch how trials play out helps people understand how the system works. Because if people are like, I don't understand the way the outcomes are happening or the way this system is working, well, we can't change it if we don't understand it. And so at least having everybody get to see what's happening brings transparency to that. So I'm going to scroll back up to questions. I'm sorry if I missed any super chats. Yes, that was that was a Harry Potter reference. Hello, Kempire. Good to see you. It was. I always thought of the opening leading to my close, and the closing was where I got to be me in a trial. When you question a jury, you're not you, you're just the people. When you question witnesses, the witness testimony needs to shine. But at closing, as an attorney, that is when you are kind of on stage, for lack of a better word. You're in front of your jury. You are talking to them about the case you presented. That is really your time to argue. So yes. Question, are arguments sort of like writing a dissertation? Katya, I've never written a dissertation, but they need to weave together and they need to be coherent. You don't want to just bury a jury in information because they got buried in information for weeks of trial sometimes. You want to pick out the most important parts for them and help highlight how those parts go to the things. So you want it to work together. Also, officers of the court never know how a jury will come to their conclusion. That's absolutely right, SC. It is for them. There was one case I did where we went back into the jury room afterwards and they had used the whole whiteboard and had sketched stuff out. I was like, look at them. Look at this. It was very interesting. And oftentimes attorneys, well, it depends on the jurisdiction, are able to talk to the jurors after a verdict or after a hang. And it can be very interesting to hear what jurors let you know and to answer their questions if you can. So you do sometimes get input from talking to a jury afterwards. Sometimes the jury is like, can we give our verdict and get the fuck out of here? We do not want to be around, depending on what goes down. And that is very interesting too. So I'm going to try to get to as many questions as I can. Anna says, I'm sure the jurors will feel the weight of what their decision will mean to a lot of people. I don't know how they can't in this case, and that can actually be an issue for this case because you hear the judge's instructions at the end, or if you watched, you heard the judge's instructions saying they have to make their verdict based on the facts as they find them and the law that they apply them to, not with regard, they cannot consider consequence, external consequence, societal impact. And he read through the entire thing saying, you can't think of any of this. You can only find the facts, apply them to the law, and you're supposed to disregard everything else. But also jurors are human, and that's going to be very, very difficult in this case. And that's why you heard the judge saying yesterday that there could be very real issues for appeal here if there is a conviction. Bree, yes, jurors can take notes during trial. There's a jury instruction that you hear if the judge allows them to use their notes during deliberation. I couldn't sit for weeks and not take notes. Like, it's part of my listening is taking notes. But you'll hear an instruction saying that notes can be an aid, but you rely on what you remember. You do not rely on somebody's notes because notes can be wrong. Bart, hello. Can you please talk about more about jury selection? How thorough is the screening process? Do you dig through people's past and social media? You shouldn't, but it does happen. With regard to the Chauvin case, I don't know what procedures they went through with looking into the jurors, and that is something that can be done. Jury research can be done in large civil cases because there's bandwidth for that. For the prosecutions that I was running, you looked at the person, you saw them when they came in, you got their name on a sheet, and you had their age. You got to find out if they had any friends or family in law enforcement, if they'd had any experience with the criminal justice system, if they had any particular relation to the kind of crime we were prosecuting. You don't want, somebody on a DUI jury that lost a family member to a DUI related crash, for instance. And then you ask them questions and go by their answers. And that's all we had. We did not dig into anything more. That can happen based on different jurisdictions. So I will do another video on voir dire and jury selection. I mean, there are jury consultants. There are different schools of thought with juries. I went with my gut and I picked a jury based on people I thought were trying to be fair, people who didn't necessarily say, oh, I can 100% be fair, because you don't really know if you've never done it before, but people who are like, I will absolutely do my best to be mindful of those things, and people who I didn't think would be put off by my style. That's the best I could ask for with a jury, and it generally worked for me. Of the trials I've watched, I thought Nelson was a good lawyer. Obviously, I think Chauvin is guilty and he had a tough job, but I thought he did well with what he had to work with. Tracy, I agree that he did well. I don't think anyone disagrees that what Chauvin did was horrible and shouldn't have happened, and that there's no reason George Floyd should have died. Whether a jury will find the necessary intent, whether they will find intervening factors, I don't know what they will find. But yes, I think he did a good job with what he had to work with. And that, again, is his job, is to find enough doubt for one juror. That is really their job, just looking for the one. But yes, I do think he did a good job. Kibby said, question, how long do you think it will take for the jurors to deliberate? Do you think they will call in a lot of evidence to look over? They will be given all of the evidence. So they will get all of the evidence. Vipe, it's so good to see you, friend. The jury will get everything. Whether they choose to go through it or not will depend on if there are things they have questions about. For the Chauvin jury, I don't know if they're going to want to look at that video again. Both sides played it a lot. We all have like a collective gut reaction to the video and to watching, George Floyd die on the street. All of us have a visceral reaction. A jury having to watch that over and over and over might very well be either traumatized by it and not want to see it again, or be desensitized to it and not want to see it again. So I don't know how much evidence they will need to look over. We will see if they ask any questions, if they ask to have readback of any testimony, and that will give some indication of what they're thinking. the more guilt generally takes less time. Like a guilty verdict generally comes in faster than a hang or an acquittal, because you're gonna get a few jurors no matter what that come out of the box like guilty, fuck this shit. You're going to get that in almost any trial. Unless of course it's very unusual that you will get not a single juror that's like, no, fuck this. This is a guilty. Now, changing that person's mind to yeah, but there's really doubt here can take time. The more jurors you have leaning towards guilt, the faster things tend to go, from my experience. So we'll see as we get on to what they do. Buzzer bites. I worry for all the lawyers and the judge and the jurors, no matter which way the verdict goes. I agree. This is, look, Chauvin's actions have not only taken the life of George Floyd, but put other law enforcement at danger, put a city in danger, put these jurors in an impossible position to try to match the law and the facts with their own emotions and their own sense of right and wrong. Because again, legal and illegal and right and wrong are two different things. It's just the actions of that one person have caused so much. And that's not to discredit the fact that there are entire systems of inequity that need more exploration and conversation than I can ever give, because that is not my area of expertise at all. But yes, I also worry. And what I have found in trials where I've had hung juries, trials where I've had guilty verdicts, trials where I've had acquittals, which are few, but there were few, and they were totally fair when they came, is that at the end of the day, it doesn't bring closure often. Though victims' families, particularly in homicides, do tend to feel better when a jury says, yes, this person did this thing that took the life of your loved one. It's not life-changing. It doesn't bring this overwhelming sense of right and wrong in the world, because still what was done to you, no matter what a verdict says, is still wrong. And that's a hard thing. So it's a hard thing. Emily asked, question, what do you think the defense strategy of using the prosecution body cam footage in their closing seems risky? Emily, I actually thought it was great. I thought that for what they need to do, and again, the defense's job is to make sure, the prosecution does their job legally, ethically, and adhering to the Constitution, but also to point out doubt. And so the job of the defense was to try to take the jury into what it is to be an officer and what the officers were dealing with before the footage that everybody is so familiar with of Chauvin kneeling on George Floyd for, in my opinion, more time than is ever going to be reasonable. But I am not a juror. I did not hear all the evidence, and it is not my decision to make. So they are bringing the jury in to the entirety of the event and the entirety of what was going on to try to, I think, explain the state of mind of the officers, explain what was going on before that. So I think with what they had, they did a good job of bringing that in and weaving it into the closing. It also kept the closing moving along and engaging. So that is a benefit too. Could it be risky? Yes, it absolutely could. Question, Tori L, for any and all, is it correct that jurors cannot have any knowledge of the case that they are selected for? Is that impossible with national cases like this? They can't have a lot of knowledge, and the judge and the attorneys question them about it and then decide if people can go through. I mean, there's difference between an awareness of a case, like, oh, I heard something happened, and which you're going to find in a case like this. You're going to find people who have heard of it. And there's a difference between, yes, I've heard of it, versus, yes, I've watched every news article or news thing on it. I've watched all the commentary on it. I have been deeply invested and want to see this case go a certain way. That can't be a juror. That would be prejudicial against the defendant. But somebody who has an awareness is not necessarily going to be somebody who's disqualified from being a juror. I'm trying to get to a lot of questions. NK Burlington, yes, it does. For those of us that are old enough to remember the OJ deliberation, it feels like that for me as well. I was in high school, but it does feel like that. Question, is it allowed for audience defendant to make faces? No, it's not. No, it's not. And it can be an issue. I've had defendants like Mad Dog at jurors, and it can be the attempt to kind of intimidate jurors can be an issue. Now, that's different than a defendant being somewhat emotional or having some emotion. But I've had family members of defendants in the back, like literally like staring at jurors, pretending to take pictures of jurors, things like that. And that can't happen. Thank you, Anika. Kaylee, question, why does the judge get to decide certain standing orders in their court, like how many lines for filing documents, etc.? I might be using the wrong terminology, law nerd, not lawyer. Kaylee, why do judges get to decide? Because it's their court and they get to decide. There are things that are decided by law that have to be, like certain things have to be the way that they are. But other things are judges' preferences, and they get to pick their preferences. They are the kings and queens of their castles, so they get to pick. So that is what that is, because they're the judge, I guess. They're like, because I said so, that's kind of what that is. And the standing orders, of course, have to be in compliance with the law of the land, but they get to decide. Does anyone know, can a judge ever change a juror's verdict? Aaron, that is a great question. So this is going to vary by the law in each jurisdiction, but there are times when a judge can look at the evidence, look at the juror's verdict, and go, there is no evidence to support that. But that would be in the case of a conviction. A judge cannot overturn an acquittal in any way. So it's going to, again, depend on the law of the land. But if there are multiple charges and the judge doesn't think that the higher charge has been proven and a jury convicts, the judge, well, the defense generally would make a motion, but the judge can bring their own motion and say, I don't think the evidence proved that. But generally, if that's the issue, the judge should have thrown away that charge after the people rested before it was given to the jury. So it would be very rare, but yes, it can sometimes happen, but only with a conviction, not with an acquittal, because you can't put somebody in double jeopardy. If a jury acquits them, that is what it is, and that is the end, and there is nothing that can be done about acquittals. They are just done. Michelle said, everyone should sit on a jury once in their life. It's truly a lesson in civics. It's a lesson in civics, and it's a lesson in trying to have difficult discussions with a group of strangers. It would be, I've never been on a jury. I want to be on a jury. I don't think that will ever happen. Maybe civil. Question, I see discussion of jurors asking questions. Do some states allow that, jurors asking questions during trials? As I didn't think it was a thing. I've been an MI juror, and the judge said no. So in some jurisdictions, jurors can ask questions during trial. It's very, very rare. Judges can ask questions, all the questions. It was often very annoying to me when a judge would butt in and start asking your witness questions. You're like, oh, would you like to be the prosecutor today? Okay, Your Honor, you go. I was doing my job. I have a plan. Please don't ask the things, but judges can butt in. Jurors can generally not ask questions of witnesses, but jurors can ask questions when they're in deliberation and the question goes to the judge, and then the judge brings in the attorneys and they sit and have a conference about how to answer the question or not answer the question. But in some jurisdictions, jurors can propose a question to, like, send a question to the bailiff to the court and go that way, but it would have to go through the bailiff in the court. But yes, jurors can ask questions. Let me catch up on, oh, my chat just jumped. So if I lost anything, I apologize. Questions. Karen, asks, have you ever taken part in a hearing or process involving a declaration or certificate of innocence? What does it involve? Is it a rarity? I have not dealt with the declaration of innocence or certificate of innocence, so I cannot help with what's involved, but it is going beyond the just like you're not criminally liable. No, that's not true. I have. In cases of like mistaken identity, I have seen this come up in court where it's like, hey, this person keeps getting picked up for this other person's same name, similar descriptions, stuff. So they need a declaration saying that they are not, in fact, this other person and they did not do this thing. But outside of that context, I don't have an answer for you. Question, can a judge make a jury go back and think about it more because they come to a decision too quickly? Only if their decision is we can't decide. So Lynna, if a jury goes out and 10 minutes later comes back and is like, we have a verdict, the judge is like, okay, they have a verdict. The judge can't do anything about it. If they come back in 3 hours and are like, we can't decide, the judge is going to be like, I'm sorry. We've been in trial for weeks and you need to try harder. So if there's a reason you can't decide, and then sometimes the judge will ask questions of the jurors, has one person put their foot down and is like, I'm not changing my mind. Is that why you can't decide? Is somebody failing to deliberate? Is there a piece of evidence that would be helpful? Is there a question we can answer? Would you like lunch? Is it too cold in the jury room? And the judge will try to accommodate the jury and send them back in. So only in the case where it's we can't decide. And the judge will be like, no, let's try harder. And then that questioning will all happen with both attorneys in, which is why the attorneys will have to be in the courthouse. So if the jury has a question, the jurors can come into the courtroom, the questions read by the judge, read to the attorneys, put on the record. It's all very much open as that goes. So let's see. I'm going to try to get to a few more questions. And then today is today's an Apple event, and I know a lot of you want to watch it. And that's what we're going to do. Question, could the prosecution have charged Chauvin with more or lesser charges so that they could convict him of something? I don't really know if there's any other lessers that fit. And that's always a thought that they can. I haven't explored what other lessers could have been charged in this case outside of the manslaughter charge. But there's also strategy in that. If a prosecutor's like, no, we have this charge, and you, jury, is going to have to look me in the face and tell me we don't have this charge. So I'm not giving you an option. I'm giving you this charge. Now, there are times that lesser includeds have to be included, but you don't have to give every single charge, because if you want to force the jury to make the harder decision, you can say, okay, but we're not charging this other stuff. And then the defense can move to include the natural lesser included crimes if that's appropriate. But you can try to use the charge to say, no, if it's not this, then it's nothing. Because what a lot of prosecutors don't want is for the jury to split the baby. And it's biblical. It's a horrible phrase. It is what's used. I have heard attorneys from all over the country talk about splitting the baby when you talk about jurors saying, you know what, we're not quite there on this, but we're not quite there on acquittal. So we're going to just compromise with the lower charge. And sometimes you don't want a jury coming to a compromise on a lesser included charge. So that can be strategic, and sometimes it's not appropriate. So Emma said, thank you, Emily, for mentioning this. People base their opinions on snippets that they see of a situation, and most of the time that's not the entire picture, which is why we have jury trials that take lots and lots of time. So let's continue. Lady in Red, thank you so much. All is well. I'm glad you caught alive. I'm sorry that it's a short one today. Question, can the defense go too far in trying to show alternatives that caused Floyd's death? there are bounds of what they're allowed to argue, but can they go too far? No, that's literally their job. It's on the prosecution to prove that those things would be not reasonable doubt. So it would be on the prosecution to prove, like, okay, look, you might want to say that there's doubt there, but that's unreasonable. It's just not at all within reason. And I think the defense gave in the Chauvin closing, the defense gave a whole spiel about aliens, and I was like, where are we going with the aliens? But trying to kind of pin aliens being the most unreasonable thing and then everything else being reasonable. I'm like, I mean, okay, but aliens is not the level of unreasonable, and then everything else that's not aliens becomes reasonable. But no, the defense, the place where defense can go too far is like misstating the law, talking about things they're not allowed to bring up. But no, not when it comes to showing alternatives, which can, as a prosecutor, be frustrating because you're like, y'all, that's just not reasonable. But you can't say that way to a jury. You can't say that is not reasonable. You have to say, this is why that's not reasonable. You also can't say, as a prosecutor, the defense is stretching the truth. The defense is not telling you the truth. Like, look, he didn't even testify. Like, you can never comment on the fact that a defendant doesn't testify because it's their constitutionally given right. So there's a lot. There's a lot there. They didn't use the Chewy defense. They did not use the Chewy defense. And I think if the defense had tried to do that, it would have been disrespectful. I think we are, at the end of the day, still talking about a man whose life was taken. So sometimes the analogies can get too quirky in a murder trial and feel almost disrespectful for me. And I think what the prosecution at the end of their rebuttal was trying to get a one-liner in with like a Grinch kind of a thing. You know, they're going to argue that Mr. Floyd's heart was too big, but really Mr. Chauvin's heart was too small. It's like, look, no one's ever going to be, if the glove doesn't fit, you must acquit. No one is there. No one is there. No one is going to have that moment unless it occurs naturally. Like, life generally doesn't work that way. That was a moment. That was a line, and that became a jury rallying cry. That's your doubt. If the glove doesn't fit, quit. If the glove doesn't fit, you must acquit. That is a jury rallying cry where a juror can go in and go, if the glove doesn't fit, you must acquit. I'm on that train. I got that. But you can't force those moments. And the defense, I think, gets a little more grace with that because they are the defense. The state can't be as cute with that because you're bringing the weight of the government against someone who's been accused of a crime. You don't really get to be cute. You know, it's just, you get to prove the evidence. You don't get to be quippy. We talked about physical notes. Yes, they can. Yes, they can. Yes, they can. I'm going to try to get to a few more questions and then we're going to peace out because then it's time for the Apple event. And I understand. And mods, if you guys need to put on the Apple event, I get it. I know everybody wants to watch it. It's starting in like literally a minute. I get it. But I'm going to try to get to just a few more questions and then peace out. I know I missed a few super chats, so I'm going to get it. And then we're going to go and we will take up more questions. We will take up a few more questions. Gadget Goddess, it's so good to see you, lovely friend. They will never select you for jury. No, they won't. Almost got on a Fed case until they found out where I worked and they didn't even let me come in. Well, at least they dismissed you early instead of keeping you for 3 days and being like, nah, boo, that's not going to happen. So I missed a few super chats. Okay, let me get to these. Thank you guys for the super chats. I appreciate it. How do they determine who should be the foreperson? Every jury is different. So the jurors decide themselves who is the foreperson and they have to vote. So they have to decide. They have to come up with their own procedure. It's like an HOA. I don't mean to make that a crass analogy, but you have to self-govern when you're on a jury and they all have to come up to a decision. Oftentimes you will see it if jurors go to lunch together and stuff, you will see the person that's naturally the leader of the group who's kind of the one holding the door sometimes for everybody as they're coming in, the one reminding someone to pick up their jacket when they're leaving court, the one who's talking to more of the jurors. So sometimes you will see who kind of is the natural leader over the course of the trial, because they do often eat lunch together. They do often interact with each other. They can't talk about the case, but they still interact because they're going through this thing together. And I've had jurors that have stayed in touch, that like exchanged information and stayed in touch. And apparently that's not uncommon. I don't know. But especially on a high profile case, they are going through something that no one else will understand. I mean, the OJ jurors might understand, the Rodney King jurors might understand, but they're going through something that only the 12 of them really fully appreciate. And so it wouldn't surprise me if they kept in touch. What protection is there for jurors once their names are named? That's a whole separate conversation. I would hope that the jurors' names wouldn't be named unless they chose that. I would hope that the media would not try to out all of the jurors or dox the jurors. Their names shouldn't be out. And then they would have to work with the court and police to put protection on their home if their homes and if their addresses and stuff gets doxed. Looking for jurors is something that chills me, and I have a lot of thoughts about it, and we can get into that another time. Question: what did you think of Nelson's cookie analogy? It's a good analogy. He didn't do it in a way that was flippant and lighthearted, so it didn't bother me. I understand why he was trying to make that analogy, because it takes it out of the world of crime, out of anything difficult, and says you have to have every single component. And that is a good analogy for you have to have every single component without it being too lighthearted and too jokey. The aliens didn't sit as well for me. The cookies is a good analogy that I've actually heard other defense attorneys use. Miss Pockets, the riot says, is there an issue with the jury taking like an extra hour to deliberate, even though they've already agreed just to get free lunch? I mean, I don't know how anyone would know that they took extra time. I imagine that this jury would want to be out. Juries get to decide what they need. If juries have voted and still need a moment or time to decompress, they can. I mean, the court lunches aren't great, but I don't think there would ever be an issue with jurors saying, hey, we're going to just go to lunch. I don't know what the issue would be. I mean, that doesn't mean there couldn't be an issue based on jurisdiction, but I don't see what it would be. Cindy M. Hello, Emily. Love your channel. Thank you. What do you think of Maxine Waters' comment and the judge subsequently telling the defense they can appeal? So, Cindy, I was not a big fan of Maxine Waters' comment. I don't think any politician, and it's not just Maxine Waters, I don't think any politician should be calling for enhanced, I believe her word was confrontation, in an already heated time. I think that's irresponsible. I think that we'd see the news reporting different if she was a Republican versus her being a Democrat, which shouldn't be the way. There should be some like, hey, we just don't try to incite violence at all. Like anybody, like nobody should be doing that. That should be a baseline. The judge was pissed, and it's because it can put the jury at fear. If she had made those comments, I wouldn't like the comments anyway if she had made them after a verdict, but after a verdict, it wouldn't impact this jury or potentially impact this jury in the same way. I think that she could have chosen her words more carefully to say people need to continue to make their voices heard, and people need to not forget that no matter what this verdict is, there's still injustices in our system. I think there's a lot of ways to convey that without using the word be more confrontational. I think that there is a number of issues the defense can appeal on, and the judge, I don't think, was wrong in his comments saying that, I'm not finding a mistrial because of those comments, because the defense asked for a mistrial based on those comments, based on Maxine Waters' comments. And the judge said, I'm not granting a mistrial based on those comments, but she may have given you an issue, a valid issue on appeal. I think if there is a conviction, there will be appeals. I think there are some issues. They might not stand, but there are definitely some issues that can come up on appeal. And the defense did a good job of preserving those. So I think that the comments, I think that the timing of the comments was irresponsible. I really do. And I don't think politicians should be calling for confrontation on any side of the spectrum. And also, you're the politicians. Make things change. Tell people why things aren't changing. Tell people how they need to vote to make things change. I think there's a lot of ways to accomplish that without frustrating a very difficult criminal prosecution that's ongoing that has a lot of people already heated. So what's up, Rich Lux? I can't live stream the Apple event. I will immediately get copyright shooketh. But I'll be talking about it on Twitter. So I will absolutely talk about it on Twitter. And I'm gonna look Anna, yes, the alien thing set the bar for reasonable doubt very high. Because if aliens are what's unreasonable, then anything's possible. So I think that set the bar high. I'm gonna do 2 more questions and then we're gonna go. I will talk about this on Friday. I linked that video. I love that video. I linked it in both of my videos about caterpillar cakes. Griff 3 baby lover. Hello. Question. Are you surprised this case will wrap up in less than a year? Yes, I'm shocked. It seems most trials are like 2 years. Yes. I did early on in this case. I did 2 podcast episodes about it and talked about the other officer involved killing that was prosecuted in Minneapolis under a lot of the same charges. And I think it took them 9 or 10 months to even bring charges in that case. And it took a number of years to go through the prosecution. So yes, I am very, very surprised how quick this moved in the middle of a pandemic. I am. I'm very, 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 very surprised. So Apple goes happy on the copyright strikes. Yes, they do. Yes, they do. Yes, they do. Cheyenne, you are not the only one. I will talk Chewy defense on Friday for sure. I'm going to do the last few chats. Gloria, thank you. Oh my God, you have Wally. I love Wally. You're welcome. You're welcome. You're welcome. Question. How many murder trials have you been a part of? I have done to jury 3 murder trials, but I have been a part of other things before I left the office, preliminary hearings, early investigations, stuff like that. So that is how many. Question, can you be called for jury duty if you are working for the government? It depends on what agency you work on, what kind of trial you're called on, and if there's a reason that you can't sit on the case because of who your employer is. But in the States, we have civil and criminal juries. So if you work for the government, but the case is a civil case between 2 companies, then it wouldn't really matter. Okay. Question, why can't jurors talk to each other about the case? Jess S. This is a fantastic question that I didn't touch on and I think is important. And then Apple event, because we're like 10 minutes in. During the case, until closing arguments and jurors are instructed on the law, they cannot discuss the case because you don't want them pre-deciding when they don't have the jury instructions and the law on the case. You don't want them to kind of pre-prejudice themselves. So they can talk about their families, their lives, their lunch, but they cannot talk about like, oh, did you see that witness sweating? Looked like a fucking liar. Like, you can't talk about the case. You can't talk about the attorneys involved in the case. You cannot discuss anything that goes on in the courtroom until you are sent back to deliberate. And once you are able to go back and deliberate, then you can. So, Zentz, you are welcome. I had been a part of other cases, but not all the way to jury. And I don't remember how many other homicide, and there are other homicide related cases, lots of them that I had been involved in, particularly homicide, DUI related homicides, but murder cases, and even capital murder cases, 3 to jury, but lots and lots of others that mostly pled. How will it affect the trial if the jury isn't supposed to be keeping up with the news? If the jury has been prejudiced by the news, it can't, well, if it comes out, it could be a mistrial, but it would be an issue for appeal if the news somehow swayed them in their decision. So that's what it is. Generally not, Perry. Does the state provide psychological care to jurors after exposing them to traumatic cases? Generally not, though it should. Because I mean, I had cases that I wanted to resolve short of jury trial just because I didn't want jurors to have to see. I didn't want anyone else to have to see other than the immediate investigators and DAs and family, because the cases were so traumatic. So they should, some jurisdictions might, that's never been my experience, but gosh, they should be. Gosh, they should be. So yeah. So they absolutely should be. Question, how will Maxine's comments affect the jury if they aren't supposed to be keeping up with the news? Well, just because they're not supposed to be watching the news doesn't mean they won't, because until they were sequestered to deliberate, they weren't told to stay off of social media. They weren't told to stay off of other things. So though they're not watching the news, it doesn't mean it didn't come up if they opened Twitter or something like that. Okay. Well, I have gone way over time. It is time for an Apple event. I appreciate you all so much. I'm going to go check in on Apple. If you guys are curious about my thoughts on the Apple event, follow me on Twitter and on Instagram. I'll be talking about it there. But gosh, we're 15 minutes into an Apple event and I'm late. So I appreciate you. Thank you for being a law nerd. Go ahead and hit all the buttony things, do the YouTubey things. I will see you on social. I will see you for Friday Night Live. I appreciate you. Bye. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.